Hello, future lawyers. We're back with 2019 bar exam questions with suggested answers from UP Law Center for Criminal Law Bar Exam. Now let's get started with part 1. Question A1. Define, distinguish the following terms: mala inse and mala prohibita, grave, less grave, and light felonies, aberratio ictus, error in personam, and praeter intentionem. Suggested answers. Letter E. When the acts complained of are inherently immoral, they are deemed mala in se, even if they are punished by special law. Accordingly, criminal intent must be clearly established with the other elements of the crime. Otherwise, no crime is committed. On the other hand, in crimes that are mala prohibita, the criminal acts are not inherently immoral but become punishable only because the law says that they are forbidden. Under Article 9 of the Revised Penal Code, grave felonies are those to which the law attaches the criminal punishment or penalties which in any of their periods are afflictive, in accordance with Article 25 of the Revised Penal Code. Less grave felonies are those which the law punishes with penalties which in their maximum period are correctional, also in accordance with Article 25. Light felonies are those infractions of law for the commission of which a penalty of arresto menor or a fine not exceeding 40,000 pesos or both is provided. Under Article 4, Paragraph 1 of the Revised Penal Code, criminal liability shall be incurred by any person committing a felony or delito, although the wrongful act done be different from that which he intended. Thus, a person committing a felony is still criminally liable if A. There is a mistake in the identity of the victim or error in personae. B. There is a mistake in the blow or aberratio ictus. And C. The injury's result is greater than that intended or praeter intentionem. Question A2. Mr. X has always been infatuated with Miss Y. Scorned by Miss Y's disregard for his feelings towards her, Mr. X came up with a plan to abduct Miss Y in order to have carnal knowledge of her with the help of his buddies, A, B, and C. On the day they decided to carry out the plan, and while surreptitiously waiting for Miss Y, C had a change of heart and left. This notwithstanding, Mr. X, A, and B continued with the plan and abducted Miss Y by forcefully taking her to a deserted house away from the city. There, Mr. X restrained Miss Y's arms while A held her legs apart. B stood as a lookout. Mr. X was then able to have carnal knowledge of Miss Y, who was resisting throughout the entire ordeal. Consequently, Mr. X was charged with the crime of forcible abduction under the revised penal code. Questions. Is the charge against Mr. X proper? Explain. Assuming that A, B, and C are also charged, may they be held criminally liable together with Mr. X? Explain. Suggested answer. No, the charge against Mr. X is not proper. Mr. X should be charged with the crime of rape. Based on the facts, the main objective of Mr. X was to have carnal knowledge of Miss Y. The crime of forcible abduction is absorbed in the crime of rape if the real objective of the accused was to rape the victim. No, only A and B may be held criminally liable together with Mr. X. Under Article 8, Paragraph 2 of the Revised Penal Code, a conspiracy exists when two or more persons come to an agreement concerning the commission of a felony and decide to commit it. With A holding Miss Y's legs apart and B standing as a lookout, they actively participated in the commission of the crime and are guilty as co conspirators. C may not be held criminally liable. C dissociated himself from the conspiracy when he had a change of heart and left. His disavowal of the conspiracy was effective since he decided not to perform his part in the conspiracy before any material act of execution leading to the rape was committed. Mere knowledge, acquiescence, or approval of the act without cooperation is not enough to constitute as a party to a conspiracy. Question A3. Mr. O, a 75-year-old retiree who has been a widower for the last 10 years, believes that at past 70, he is licensed to engage in voyeurism to satisfy his lustful desires. If not peeping into the neighbors' rooms through his powerful single cylinder telescope, he would trail young, shapely girls along the hallways and corridors of shopping malls. While going up to the escalator, he stayed a step behind a miniskirted 20-year-old girl and, in the heat of the moment, put his hand on her left buttock and massaged it. The girl screamed and hollered for help. Mr. O was thus apprehended and charged with acts of lasciviousness under Article 336 of the Revised Penal Code. Mr. O's counsel, however, claimed that Mr. O should be charged with the crime of unjust vexation. Question. Is the contention of Mr. O's counsel tenable? Suggested answer. No, the contention of Mr. O's counsel is untenable. Under Article 336 of the Revised Penal Code, the elements of acts of lasciviousness are 1. That the offender commits any act of lasciviousness or lewdness. 2. That the lascivious act is committed against a person of either sex. And 3. That it is done under any of the following circumstances. A. By using threat, force, or intimidation. B. When the offended party is deprived of reason or otherwise unconscious. C. By means of fraudulently machination or grave abuse of authority. Or D. When the offended party is under 12 years of age or is demented. Lascivious conduct is defined as the intentional touching, either directly or through clothing, of the genitalia, anus, groin, breast, inner thigh, or buttock, or the introduction of any object into the genitalia, anus, or mouth of any person, whether of the same or opposite sex, with an intent to abuse, humiliate, harass, degrade, or arouse or gratify the sexual desire of any person, bestiality, masturbation, lascivious exhibition of the genitalias or public area of a person. Here, when Mr. O touched the buttocks of the offended party, he was animated with lewdness, thus, acts of lasciviousness were committed. Question A4. In dire need of money, Mr. R decided to steal from his next door neighbor, Mrs. V. On the night of May 15, 2010, Mr. R proceeded with his plan and entered Mrs. V's bedroom by breaking one of the windows from the outside. Finding Mrs. V sound asleep, he silently foraged through her cabinet and stashed all the bundles of cash and jewelries as he could find. As Mr. R was about to leave, he heard Mrs. V shout, "Stop, or I will shoot you." And when he turned around, he saw Mrs. V cocking a rifle, which was pointed at him. Fearing for his life, Mr. R then lunged at Mrs. V and was able to wrest the gun away from her. Thereafter, Mr. R shot Mrs. V, which resulted to her death. Mr. R's deeds were discovered on the very same night as he was seen by law enforcement authorities fleeing from the scene. Questions. What crime or crimes did Mr. R commit under the revised penal code? Explain. B. Based on your answer in question A, within what period should the prosecution file a criminal charge against Mr. R in order to avoid prescription? Explain. C. May Mr. R validly invoke the justifying circumstance of self defense? Explain. Suggested answers. Mr. R committed robbery with homicide under Article 293 in relation to Article 294, Paragraph 1 of the Revised Penal Code. The elements of the crime are A. Taking of personal property with the use of violence or intimidation against the person. B. Property taken belongs to another. C. The taking is characterized by the intent to gain or animus lucrandi. And D. On the occasion or by reason of the robbery, the crime of homicide, as used in its generic sense, was committed. It must be established that the original criminal design of the malefactor is to commit robbery, and the killing is merely incidental thereto. Here, Mr. R's intent to commit robbery preceded the taking of Mrs. V's life. The killing took place on the occasion or by reason of the robbery. The prosecution should file the criminal charge within 20 years from the date of discovery. Under Article 90 of the Revised Penal Code, crimes punishable by reclusion perpetua shall prescribe in 20 years. Here, the crime of robbery with homicide is punished by reclusion perpetua. Thus, the crime shall prescribe in 20 years. No, Mr. R may not invoke the justifying circumstance of self defense. One of the elements of self defense is unlawful aggression. Here, there was no unlawful aggression because Mrs. V was the owner of the cash and jewelry, and as such, she had every right to defend her property. That act was done in order to repel the aggression which, had it been effective, would have endangered the whole success of the robbery committed. It was done in the final analysis in order to defend the possession of the stolen property. It was therefore an act which tended to ensure practical termination of the robbery, to ensure the robbers the possession and enjoyment of the goods taken. There was no unlawful aggression on the part of Mrs. V, who, defending her property, as the owner of the cash and jewelry, Mrs. V had the lawful right to take back the goods stolen by Mr. R, who was actually the unlawful aggressor. Question A5. In August 2018, B entered into a contract with S for the purchase of the latter's second-hand car in the amount of 400,000 pesos payable in two equal monthly installments. Simultaneous with the signing of the contract and S's turnover of the car keys, B executed, issued, and delivered two post-dated checks, all payable to S, with the assurance that they will all be honored on their respective maturity dates. However, all two checks were dishonored for being drawn against insufficient funds. Consequently, notices, therefore, were duly issued and received by B, but this notwithstanding, no payment arrangements were made by him. Further, upon S's investigation, it was uncovered that B's checking account had only 50,000 when it was opened in June 2018, and no further deposits were made after that. S also found out that B knew fully well of such circumstances at the time that he issued the two checks. What crime or crimes should B be charged with and for how many counts? Explain. Suggested answer. B should be charged with one count of estafa and two counts of violation of Batas Pambansa Bilang 22 or the Bouncing Checks Law under Article 315, Paragraph 2D of the Revised Penal Code. Estafa by post-dating a check or issuing a check in payment of an obligation is committed when A. The offender post-dated a check or issued a check in payment of an obligation, and B. Such post-dating or issuing a check was done when the offender had no funds in the bank or his funds deposited therein were not sufficient to cover the amount of the check. Here, B's act of post-dating checks in payment of an obligation was the efficient cause of the defraudation. Post-dating the checks was committed prior to the simultaneously with the commission of the fraud. B should also be charged with two counts of violation of BP Bilang 22. BP Bilang 22 may be violated by making or drawing and issuing any check to apply on account or for value, knowing at the time of the issue that he does not have sufficient funds in or credit with a jury bank for the payment of such check in full upon its presentment, which check is subsequently dishonored by the drawing bank for insufficient funds or credit, or would have been dishonored for the same reason had not the drawer, without any valid reason, ordered the bank to stop payment. Here, all elements of the offense are present. B issued two checks which were subsequently dishonored by the drawing bank for insufficient funds. The gravamen of BP Bilang 22 is the issuance of the check. Thus, the issuance of each bouncing check constitutes as one count of the offense. While a BP Bilang 22 case and an estafa case may be rooted from an incidental set of facts, they nevertheless present different causes of action, which, under the law, are considered separate, distinct, and independent. Question A6. Mr. A had a long standing feud with Mr. B. As payback for Mr. B's numerous transgressions against him, Mr. A planned to burn down Mr. B's rest house. One night, Mr. A went to the rest house and started pouring gasoline on its walls. However, just as Mr. A had lit the match for burning, he was discovered by Mr. B's caretaker, Miss C, and was consequently prevented from setting the rest house on fire. Mr. A was then charged with frustrated arson. Questions. Is the charge of frustrated arson proper? Explain. Assuming that Mr. A successfully burned down Mr. B's rest house and as a result, Miss C was trapped therein and was subsequently killed in the fire, what crime or crimes did Mr. A commit? Explain. Suggested answer. No, the proper charge is attempted arson. Under Article 6 of the Revised Penal Code, there is an attempt when the offender commences the commission of a felony directly by overt acts and does not perform all the acts of execution which should produce the felony by reason of some cause or accident other than his own spontaneous desistance. Here, Mr. A commenced the commission of arson by pouring gasoline on the house and lighting a match. However, he did not perform all the acts of execution, which includes setting the rest house on fire. Thus, Mr. A should only be liable for attempted arson. In cases where both burning and the death occur, in order to determine what crime was committed, there is a need to ascertain the main objective of the malefactor. If the main objective is the burning of the building or edifice, but death results by reason or on occasion of arson, the crime is simply arson and the resulting homicide is absorbed. If the main objective is to kill a particular person who may be in the building or edifice, when fire is resorted to as a means to accomplish such goal, the crime committed is murder only. And if the objective is to kill a particular person, and in fact the offender has already done so, but the fire is resorted to as a means to cover up the killing, then there are two separate and distinct crimes committed: homicide or murder, and arson. Here, the main purpose was to burn the house, and the death of Miss C was only incidental. Hence, arson was committed and the homicide is absorbed. Question A7. Mr. L is a newspaper reporter who writes about news items concerning the judiciary. Mr. L believed that the members of the judiciary can be criticized and exposed for the prohibited acts that they commit by virtue of the public nature of their offices. Upon receiving numerous complaints from private citizens, Mr. L released a scathing newspaper expose involving Judge G and his alleged acts constituting graft and corruption. Consequently, Mr. L was charged with the crime of libel. In response, Mr. L contended that truth is a valid defense in libel, and in this relation claimed that he was only exposing the truth regarding Judge G's misdeeds. Further, Mr. L contended that in any event, his expose on Judge G is based on the complaints he received from private citizens and, as such, should be deemed as a mere fair commentary on a matter of public interest. Questions. Are the contentions of Mr. L tenable? Explain. What are the effect on the criminal liability of an accused if he or she publishes a libelous article on an online news platform? Explain. Suggested answers. Mr. L's contention the truth is a valid defense in libel is tenable. Under Article 361 of the Revised Penal Code, if the defamatory statement is made against a public official with respect to the discharge of his official duties and functions, and the truth of the allegations is shown, the accused will be entitled to an acquittal even though he does not prove that the imputation was published with good motives and for justifiable ends. The accused may be liable under Republic Act number 10175 or the Cybercrime Prevention Act of 2012. Under Section 4C, Paragraph 4, a cybercrime offense includes the unlawful or prohibited acts of libel as defined in Article 355 of the Revised Penal Code committed through a computer system or any other similar means which may be devised in the future. Thus, RA 10175 penalizes the publication of a libelous article on an online news platform, and the penalty to be imposed shall be 1 degree higher than that provided under the Revised Penal Code pursuant to Section 6 of RA 10175. Question A8. After a successful entrapment operation by the Philippine Drug Enforcement Agency, Mr. D, a known drug pusher, was arrested on January 15, 2019, for having been caught in flagrante delicto selling a pack of shabu, a prohibited drug, to the pusher buyer. Consequently, Mr. B was frisked by the arresting officer and aluminum foils, plastic lighters, and another plastic sachet of shabu were obtained from him. The items were marked immediately upon confiscation and they were likewise inventoried and photographed at the place of arrest. Throughout the process, a media representative was able to witness the conduct of the marking, inventory, and photography of the seized items in the presence of Mr. D. Mr. D was then charged with the crimes of illegal sale and illegal possession of dangerous drugs. In defense, he lamented that the chain of custody procedure under Article 2, Section 21 of the Comprehensive Dangerous Drugs Act of 2002, Republic Act number 9165 as amended, was not followed because only a media representative was present. In response, the prosecution maintained that the said media representative was a very credible reporter, and as such, the presence of any other witness was unnecessary. Questions. Was the chain of custody procedure validly complied with in this case? If not, was the deviation from such procedure justified? Explain. What is the consequence of an unjustified deviation from the chain of custody rule to the criminal case against Mr. D? Explain. Suggested answer. No, the chain of custody was not validly complied with. Under Section 21 of RA 9165 as amended by Republic Act 10640, the presence of at least two witnesses is required. One, an elected public official, and two, a representative from the media or a representative from the National Prosecution Service. Here, only a media representative was present to witness the conduct of marking, inventory, and photography. Further, the credibility of the media reporter as the lone witness is in a bypassed operation is neither a plausible explanation nor an acceptable justification for the PDEA's noncompliance with the chain of custody rule. The Supreme Court listed the following acceptable justifications in case of the absence of witnesses. 1. Their attendance was impossible because the place of arrest was a remote area. 2. Their safety was threatened by an immediate retaliatory action of the accused. And 3. Earnest efforts to secure the presence of the witnesses within the period required under Article 125 of the revised Penal Code proved futile through no fault of the arresting officers. The unjustified deviation from the chain of custody rule would lead to Mr. D's acquittal. Well settled is the rule that the procedure under Section 21 is a matter of substantive law and cannot be brushed aside as a simple procedural technicality. Question A9. X and Y approached Mayor Z and requested him to solemnize their marriage. On the day of the ceremony, X and Y proceeded to Mayor Z's office, but he was not there. Mayor Z's chief of staff, Mr. Yu, however, represented that he himself can solemnize their marriage and just have Mayor Z sign the marriage certificate when the latter comes back. Consequently, upon X and Y's assent, Mr. Yu solemnized the marriage, despite his lack of authority, therefore. Questions. What crime may Mr. Yu be charged with under the revised penal code? Explain. Assuming that Mayor Z signed the marriage certificate, which stated that he solemnized the marriage of X and Y, what crime may Mayor X be charged with under the revised penal code? Explain. Suggested answer. Mr. Yu can be charged with the crime of usurpation of authority or official functions. Under Article 177 of the Revised Penal Code, usurpation of authority may be committed by performing any act pertaining to any person in authority or public officer of the Philippine government or any foreign government or any agency thereof under the pretense of official position and without being lawfully entitled to do so. Here, despite his lack of authority, Mr. Yu knowingly solemnized the marriage pertaining to Mayor Z. Mayor Z may be charged with falsification under Article 171, Paragraph 2 of the Revised Penal Code. Its elements are 1. That the offender is a public officer, 2. That he takes advantage of his official position, and 3. That he falsifies a document by causing it to appear that persons have participated in any act or proceeding when they did not in fact so participate. Here, all elements of the crime are present. Mayor Z signed the marriage certificate, which states that he solemnized the marriage of X and Y, when in fact he did not participate in its solemnization. Last question for part 1. Question A10. Distinguish rebellion under the revised penal code and terrorism under the Human Security Act of 2007. Suggested answer. Under Article 1314 of the Revised Penal Code, rebellion is, by nature, a crime of the masses or of a multitude. It is a vast movement of men and a complex net of intrigues and plots. Its elements are 1. That there be a public uprising and taking arms against the government, and 2. That the purpose of the uprising or movement is either to a. Remove from the allegiance to said government or its laws the territory of the Philippines or any part thereof or any body of land, naval, or other armed forces, or B. Deprive the chief executive of Congress wholly or partly or partially of any of their powers and prerogatives. Under Article 9372 or the Human Security Act of 2007, rebellion may be subsumed in the crime of terrorism. It is one of the means by which terrorism can be committed. Section 3 states that a person who commits an act punishable as rebellion, thereby sowing and creating a condition of widespread and extraordinary fear and panic among the populace in order to coerce the government to give in to an unlawful demand, shall be guilty of the crime of terrorism. End of part one. Thank you for watching. Bye.